There is not a crime here. The Clenneys have not committed a crime.
This morning, we're shining a spotlight on the computer crimes allegations brought against OnlyFans model Courtney Clenney and her parents. Now, according to the state of Florida, Clenney's parents unlawfully accessed Christian Obumseli's computer instead of turning it over to police as evidence. But the Clenneys and their attorneys are saying no crime has been committed. It was a shared laptop between Courtney and Christian, and accessing it was part of Courtney's defense.
The access to the computer was part of defense of Courtney Clenney and was an authorized access, and it does not fall within the parameters of the statute that they charged.
And now Clenney's defense team is alleging prosecutorial misconduct, claiming that these computer charges were brought after the state unlawfully breached attorney-client privileged communications by pulling a message with her attorneys from her iCloud account. We have Courtney Clenney's attorneys here live on the show now. Let's bring them in. Attorneys Sabrina Puglisi and Frank Prieto. Good morning to you both. Thank you for being here. Could we start with the laptop not being seized initially? Could we just start there? We know police processed the apartment that they were living in, and it was never taken. I'm curious as to why, if police thought there may have been evidence that would be material to this, why it wasn't seized in the first place. And by all means, if either of you, I know you're handling various aspects of this, want to just jump in with the questions, by all means.
Sure, Julie, I can answer that question. Obviously, I'll defer any more significant legal questions to the legal team. We had to get on board since we were basically conflicted off that case. But yes, the police didn't seize it. And obviously, we researched very carefully what our ethical obligations are with regard to gathering evidence. But as defense attorneys, we are entitled to investigate our case. We did everything right. We wrote property receipts for that computer. We turned it over to our expert for analysis. And quite honestly, it is an evidence. There's nothing on it. So we did everything right. And unfortunately, the state used their perception that there's some type of crime involved to access attorney-client privilege materials.
Frank, and let's dive in more to that and the reason you guys had to conflict off of this case. So my understanding, and Sabrina, I'll go to you on this, please. My understanding is that there were some iCloud messages that were retrieved. And on these messages, it was a group text. And you and Frank were on the text along with Courtney's mom and dad and Courtney. And through reading those messages, investigators realized that her laptop was in the custody of an expert that you all hired to do a forensic download to see if there was anything beneficial to your case. And they go to that guy's office and serve the search warrant there and take it there. But if not for going through your text message with your clients, I should say, it's my understanding you represent the parents too, they wouldn't have found this information. Is that right?
Yeah, Julie, absolutely. And in fact, I don't know if you said this, but I just want to make sure it's clear. Courtney was not part of that group chat. She'd been in custody when we formed the group chat. It was with Mr. and Mrs. Clenney, the parents, who we do represent. We have a retainer agreement with them, unlike what the state says. But, you know, what's most disturbing about this whole thing is the invasion of the defense camp. There are few things more sacred in the law than attorney-client privilege. And it's because so that attorneys can feel free to speak with their clients, to talk about the case, to talk about their impressions, to talk about possible witnesses. The fact that the state has read all of this, it's just so wrong.
I hear what you're saying. And now let's take it a step further for our lovers of the law watching at home. So because you're on those text messages, you both did the right thing as lawyers and said, well, we're going to conflict off of the representation of Courtney's parents for this case. Is that accurate?
If you look, Julie, we're listed
absolutely
as witnesses.
Yeah, that's what I was going to say, right? Yeah.
So, yeah, Julie, absolutely. And it's the right thing to do. We're the way the state formulated their arrest warrant for the Clenneys, made it sound almost as if the attorneys are complicit with some type of wrongdoing, and nothing could be further from the truth. As I indicated earlier, we did the right thing ethically, professionally. I researched the ethical opinions and advisory opinions of the Florida Bar prior to handling any type of evidence in this case, and the case law supports us. And it is, to just echo what Sabrina said, it's one of the most disturbing things I've ever seen a prosecutor do. Julie, you're a former prosecutor for Allegheny County. You know that a prosecutor also has an ethical and duty to protect defendants and their rights. As soon as they saw attorneys were involved in these communications, they should have got a filter team. They should have done something to protect the interests of Courtney.
Right. Oh, you're absolutely right, Frank. Absolutely. And the fact that also, I mean, did they think you wouldn't find out about this with your investigator, suddenly, getting a knock at the door and, hey, we're here to take the laptop? The logic here, I'm having a hard time following where the state was going with all this. And so with your motion that you drafted, tell me, please, what is the exact relief that you're hoping for here with the case with respect to Courtney? And I want to be clear, too. Are you still repping Courtney on the computer crimes allegations because she wasn't part of that text?
Julie, I'll jump in. No, we are not representing Courtney on the unlawful access charge.
Got it.
One of our colleagues and well-respected attorney here in Miami, Ms. Tara Kawas, is representing her. And we have Jude Fascidomo and Mickey Ratson have come in to represent the Clenneys on that charge. So we're seeking relief, and somewhat the cases are obviously related because of the invasion of the defense camp for the homicide charge. There's a lot of issues that will cross over with the defense for the unlawful access charge. But we are seeking to figure out, what did the state do when they realized that they're accessing attorney-client communications? Did they set up a filter team? Was there some type of protocol set up? So we're moving to compel that information. We need to know what state attorneys have seen it, because down the pike coming is going to be a motion to recuse at least these prosecutors, if not the entire office of the state attorney, off this case. If they've seen our privileged information, our private communications, our impressions of the case, consultations with experts were discussed, it's a complete invasion of the defense camp. So we're asking to compel all that information, and also we will be moving to disqualify the state attorney's office off the case.
Wow, this is big stuff. Do you have a hearing date set for this?
I believe we're set for March 8th.
Okay. Oh, that's soon. Okay. Wow. Yeah. I hope we can have our cameras there for that. I would imagine there are going to be fireworks for this. So to be clear, because it's definitely an in the weeds kind of thing, you both are still representing Courtney on the homicide case. We had seen that her parents had different counsel, and now she does as well for the cases alleging that there was any misconduct with the computer. And back to that, I think what I'm having a hard time understanding is how they could have left it behind if they thought that there was great evidence. They went through that apartment, they did process it. Tell me about what you know about it being a shared device between Courtney and Christian.
Yeah, Julie, similar to a husband and a wife that, live together, and I have my own laptop, my husband has his own laptop, but I know his passwords, he knows mine, and if I needed to go onto his laptop, I could. That's the simple fact of it, is that they shared their passwords with each other. If she needed to access that computer, she could, and we have, with her permission. And the police obviously didn't think it was evidence. And honestly, there is no evidence on there of value that would do anything for the case. That's why this is all just so egregious. This is all a ruse to try to discredit the parents, to try to discredit the attorneys, to take a look into what we're doing, because I guess they don't feel confident enough in their case because they know she acted in self-defense on that day.
Sabrina, thank you for all of that. And Frank, thank you to you as well. We're out of time, but this has been very helpful. It's been very illuminating, everything that you both shared in your motion and with our viewing audience today. I know you'll keep us posted if anything else develops in the meantime, but otherwise we will see you on March 8th. And as I always say, I'm very much looking forward to seeing you both in the courtroom at trial. Take good care.
Thanks, Julie.
Thank you.